is the Honorable Congresswoman Gerville Luistro.
Good morning, Secretary.
Good morning, ma'am.
You've been a prominent political figure in Cavite, I believe for around 3 decades, as SB member, as governor, and ultimately as member of the House of Representatives representing your district. In 2022, you accepted the appointment as Secretary of Justice under the current administration. So, can you walk us through, Secretary, about your transition from being an elective official to appointive official?
It was an honor to be offered the position of Secretary of Justice. Something I didn't expect. I was expecting to become the majority leader of the House of Representatives. But because of this offer, I thought that probably it's probably the pinnacle or one of the pinnacles of a lawyer's career that he becomes a Secretary of Justice. And I accepted the position, and I accepted it as a challenge for reform. That's why I think that the JBC would be familiar with the reforms that we have instituted in the Department of Justice, and it's been a very fulfilling experience so far. Very challenging still because of the circumstances surrounding many of the controversies that we have to face as a Department of Justice.
For my second question, in 2022, the 7th District of Cavite was left without a congressional representative due to your appointment, until, of course, Congressman Ping Remulla was elected in 2023. The question, Secretary, is, if appointed as Ombudsman, you would once again be leaving an office, this time the Department of Justice. So, what assurance can you give to the Filipino people that this time, as Ombudsman, you would see your mandate through and not relinquish it prematurely?
I actually wasn't thinking of being Ombudsman when I accepted the post of Secretary of Justice. I wanted to stay for the whole 6 years. But when I saw what was happening to our country, I saw the impunity of corruption. I thought that it might be the highest form of public service to offer myself as available for the position. Of course, it will depend on many factors, if I will be appointed or not. But I believe that staying the course is most important, especially in the job of the Ombudsman. And I think that the design of the office of the Ombudsman has already shown that one cannot run for public office anymore. One who accepts the office of the Ombudsman does so with the colatilia that there will be no more politics after, especially at the age that I'll be retiring if I'm accepted or appointed to the post of Ombudsman. I'll be retiring. The term will be over at the age of 71, turning 72. I think by that time, I would have reached the peak of my prowess physically and intellectually. And we don't really know if it will be on the decline already. But I think that the best years are here ahead of us, and that this problem has to be solved. I will provide, I believe, the leadership needed to curb corruption, to stop corruption in our country.
So, does that mean that you will be finishing your tenure in the Ombudsman if given the chance to be appointed as such?
I hope so. I hope so. God willing, I'll be staying there. Yes.
For my next question, Secretary, of course, you are the proponent and the author of Circular number 15 and number 28. This is the rule which mandated for an increased amount of evidence from probable cause to reasonable certainty of conviction standard. The question, Secretary, is if appointed as Ombudsman, would you adopt the same standard of evidence in the prosecution in the office of the Ombudsman?
I believe so. Maybe even a higher form. But prima facie would be a reasonable amount of evidence to be able to file a case, because many of the cases decided by the Ombudsman seem to be always dismissed. Many of the decided cases of the Ombudsman, especially dismissal of ranking government officials, are usually reversed by the Court of Appeals. So we have to study the cases filed and why this happens. I believe that the higher iota of evidence will help make this decision stronger and more final, and have an imprint on people that the Ombudsman means business.
For the next question, Secretary, under the 2022 rules of the Ombudsman, I'm sure you are aware of this, the committee reports from Congress should be subjected to case build-up, and the same should be considered non-adversarial and should not be docketed yet. However, that rule has been changed. In 2025, they provided for a rule that once received, the same should be docketed and subjected to preliminary investigation right away. If given the chance to be the next Ombudsman, which rule are you going to adopt?
I think that immediately docketing a report would not be advantageous to the Office of the Ombudsman. I believe that the flexibility is needed to be able to do a case build-up. And that, because in my experience, I have received some committee reports or partial committee reports from Congress. And then they asked me, have you filed the case? But the committee report did not contain the evidence needed. So we still have to do a case build-up. I mean, it puts you on the right track on where to investigate, but it does not provide the necessary evidence. So how can you treat it immediately as a docketed case? I think that it's more important that we do a case build-up first before docketing a case.
Similarly, Secretary, the Commission on Audit is transmitting their decision to the Ombudsman. But it is not clear as well under the rules of the Ombudsman whether the same should be treated for purposes of preliminary investigation right away or otherwise. What is your opinion with respect to the appreciation that the Ombudsman should be giving to the decision of the Commission on Audit?
There should immediately be a case conference between the COA and the Office of the Ombudsman to determine if the acts or if the disallowances contained in any COA report is actionable or not. I think that's most important. If there is a case conference to clear the issues that have been raised in the COA report, I think that it will go a longer way. That single meeting will go a long way in determining whether a case is actionable or not.
By case conference, Secretary, does that mean that you will be subjecting the same to a case build-up before the same can be considered for preliminary investigation?
Definitely, because we will have to prosecute it in court. We will have to present the evidence. If we do not believe in our evidence, how can we pursue it relentlessly, tirelessly, and passionately? I think that having a very dreary way of presenting evidence is not the way to win a case.
And given the very challenging task and mandate to the Office of the Ombudsman, I wish to ask, Secretary, would you advocate for a power to issue subpoena of bank records for Ombudsman?
I believe that that power exists already. I mean, the power to get bank records exists already with the Office of the Ombudsman.
Nonetheless, Mr. Secretary, with all due respect, there is a Supreme Court decision which says that the same is still subject to the court order. So, in my interpretation, it went back to the original jurisprudence that it has to be a court order which will allow us to look into the bank records given the stringent requirement of the bank secrecy law. If you will be given the chance to propose a legislative measure, would you want that the Ombudsman be given the power to subpoena bank records without necessarily securing for a court order?
I would advocate that. I don't think that filtering the move through the judiciary is an assurance that the case will go properly. I think that the immediacy of the action is what is needed here, so that the momentum in building up a case will not be lost by having to go through a court process which can take forever sometimes. Not always, but sometimes.
That will be a stern warning for the erring public officials. And for my last question, Secretary, it is also tedious to secure a freeze order, which is being initiated by AMLA. I believe this is with the Court of Appeals. Would you advocate as well that the Ombudsman be given its own power to issue freeze order?
I wouldn't do that. What I would do is, if it's a property, I would annotate it in the title. If it's money, I would give notice to the bank that that account is under investigation, and then go to the court for an actual freeze order. I think that that draws the line already, because that's already going into the control process of a property or monies that are in question. So I think that a court order would suffice in that case, or would be needed in that case.
Last question, Secretary. Of course, all the applicants are qualified. As a matter of fact, the JBC is tasked to select and nominate the best qualified to the position of the Ombudsman. Ano pong meron kayo na wala ang ibang applicants?
I haven't gone into the credentials of my co-applicants, but what I have is leadership. I think that I have been a leader for most of my life. I have gotten things done. I have a transformative type of leadership that I want to use for this office. And that's the first, I think. That's the most important attribute that will set me apart from the others.
Thank you, Mr. Secretary, and good luck on your application.
Thank you, ma'am.